Well, it's a great privilege for me to be here, and it's a wonderfully privileging and also happy making to be introduced by Katie Young. And I don't think I can quite believe everything she said, but I'm most grateful for her generosity. The title of my talk is Rights in a Global World. The rhetoric of rights is frequently invoked in contemporary moral and political discussions. And they're invoked in a great many different contexts, including democratic rights in protesting against authoritarian abuse, rights to personal liberties in defending autonomies in private life, civil rights in demanding basic political freedoms, economic rights against hunger and deprivation, health rights for medical care, women's right not to be subjected to gender discrimination, gay and lesbian rights to safeguard freedoms to pursue minority lifestyles, and so on. Appealing to human rights is omnipresent in the contemporary world. And increasingly, the invoking of rights has moved beyond national borders, making claims on behalf of all people for what are seen as universal human rights. These cannot, of course, be legal rights, since there is no sovereign global state that can legislate laws for the world in a way a national government can do for laws of a particular country. These claims must be seen, in one sense or other, as ethical demands, going well beyond legislation. Indeed, as will be presently argued, human rights in general, even within a nation, may best be seen as constitutively ethical demands, which can inspire legislation and motivate social and individual action, and so on. And yet, despite the tremendous appeal of the idea of human rights, it's also seen by many as being intellectually frail, lacking in foundation, and perhaps even in coherence and cogency. It's certainly true that frequent use of the language of rights of all human beings, which can be seen in many practical arguments and pronouncements, has not been adequately matched by critical scrutiny of the basis and congruity of the underlying concepts. A conference of the kind we are having here at Boston College is a good opportunity to do what we can to reduce this rift, as Katie Young, the chair and I think very much involved and if not leader of the symposium, has also tried to do in her own work. I've also attempted to deal with this gap, particularly in my book, The Idea of Justice, to which Katie made a kind reference, and in the papers that went with that 2009 monograph. I've certainly succeeded in generating a lot of arguments, a lot of heated arguments too. One of the discussions occurred right here in Boston College. I think you were referring to that. But I'm less certain that I've succeeded in persuading the skeptics that there need not be such a gulf. In some ways, this lecture is a continuation of my attempt to pursue this objective, but I must also take particular note of the fact that I'm speaking at a symposium on the future of economic and social rights in particular, the inclusion of which among human rights sometimes generates further skepticism, at least in some minds. Is there really a difference between ethical standing of first-generation rights involving liberty and personal freedoms, and second-generation rights, as they're sometimes called, including economic and social rights? The distinction is easy enough to understand, but it's not at all clear why that difference would matter critically in their respective ethical standings. It's sometimes argued that with second-generation rights, it's possible that many acknowledged rights, e.g., the right not to be hungry or to remain illiterate, may be impossible to fulfill for all, especially in the poorer countries. Does that make a difference? Surely the right of personal liberty for all may also be impossible to guarantee for all, given the inescapable presence of homicides, crimes, and violence in all countries. Similarly, there is no real distinction, as I see it, arising from the belief, which has sometimes been aired, that for respecting the liberty of the individual, the state does not have to do anything but desist from intruding into private lives of people, whereas for fulfilling people's putative rights to such amenities as healthcare or education or social safety net, the state has to do many active things, including, of course, finding money for them. But this argument, too, cannot possibly be right, since the state may have to do many things and find resources for them, too, for preventing violations of liberty, for example, of people's right to live, rather than die in murders, riots, or terrorist activities, or to go and listen to a concert in Paris. This point should not be too hard to grasp soon after so many things that's happening in Europe and northern Nigeria and other parts of the world. The role of positive action by the state in guaranteeing both first generation and second generation rights must be seen as important. And while there is a distinction there, it's not why that distinction should be seen as being relevant here. If particularly the claim is that rights are ethical rights, and the question is whether you can find ethical reasoning for each of them. The real issue then is the legitimacy of the idea of ethical rights in general, including human rights of all kinds, to be distinguished from already legislated legal rights. Any dissociation of rights from immediate legality was firmly denounced by no less than Jeremy Bentham in his treatise Anarchical Fallacies in 1792, written shortly after the French Revolution, following the Declaration of the Rights of Man. Bentham argued that the idea of natural rights is simple nonsense. I quote, "Natural and imprescriptible rights." An American phrase, he says, rhetorical nonsense, nonsense upon stilts, unquote. I take it nonsense upon stilts is some kind of an artificially elevated nonsense. The denial of the legitimacy of non-legal rights remains very alive today, and despite persistent use of the idea of human rights in momentous affairs of the world, there are many who see the idea of human rights preceding legislation as no more than, quote-unquote, bawling upon paper, shouting on paper, to use another of Bentham's ridicule of the French rights of man. However, if the rights are interpreted in an ethical rather than immediately legal context, they cannot be dismissed as nonsense on the grounds that Bentham offered in his classic Hatchet Job. Legal rights do not preempt the domain of discourse, preempted the domain of discourse on rights. In the case of the ethical idea of rights, any connection with law or legislation may not be constitutive, but indirectly relevant in the sense that social ethics may give reason for undertaking legislative initiatives. In fact, in a celebrated essay, Are There Any Natural Rights?, Herbert Hart has argued, it's an essay in 1955, that people, I quote, speak of their moral rights mainly when advocating their incorporation in legal systems, unquote. This still leaves, however, the question, what can give a claim of something being a moral right any standing as an ethical or political articulation? It's possible to argue that the force of the ethical claim must depend on the strength of the reasoning behind the claim. The survivability of a claim in public reasoning can be seen, as John Rawls has argued, as an indicator of the objectivity of that claim. So I quote from Rawls, "The first essential is that the conception of objectivity must establish a public framework of thought sufficient for the concept of judgment to apply and for conclusions to be reached on the basis of reasons and evidence after discussion and due reflection, unquote. Rawls goes on to argue, I quote again, to say that a political conviction is objective is to say there are reasons specified by reason and mutually recognizable political conception, satisfying those essential, sufficient to convince all reasonable persons that it is reasonable, unquote. There's a long history, I mean, I agree with that position. There's a long history of invoking the idea of rights that are not, or at least not yet, legislated into the legal framework. In fact, the American Declaration of Independence took it to be self-evident that everyone, I quote, is endowed by the Creator with certain inalienable rights. And 13 years later, in 1789, the French Declaration of the Right of Man, without referring to God, asserted that, quote-unquote, men are born and remain free and equal in rights. However, Jeremy Bentham did not wait long, as was mentioned earlier, to propose the total dismissal of all such claims. Bentham's dismissal of human rights came with amazing declaratory speed. I quote, "Right, the substantive right, is the child of law. From real laws come real rights, but from imaginary laws, from laws of nature, can only come imaginary rights," unquote. Bentham's rejection of the idea of natural rights of man depends on the rhetoric of privileged use of the term of rights, confining its use to specifically legal interpretations. However, insofar as human rights are taken to be significant ethical claims, Bentham pointed to the fact that they do not necessarily have any legal or institutional force, at least not yet, is as obvious as it is irrelevant. The right comparison surely is between, one, a utility-based ethics championed by Bentham himself, which gives fundamental ethical importance to utilities but none to human rights. That's where the battle is with human rights. And two, an ethics that makes room for the normative significance of human rights, as the advocates of rights of man did, linked with the basic importance of human freedom and related to that with the corresponding social responsibilities. I've tried to discuss elsewhere in my Herbert Hart Memorial Lecture at Oxford, called Rights, Laws, and Language, was published in the Oxford Journal of Legal Studies in 2011, that how ethics might, discuss how ethics might enter in providing appropriate reading of the motivation behind the language used in existing laws. Just as utilitarian ethical reasoning takes the form of insisting that the utilities of the relevant persons must be taken into account in deciding on what should be done, the human rights approach demands that the importance of the freedom that are incorporated in the form of human rights must be given normative recognition. In fact, even as Bentham was busy writing down his dismissal of the rights of man in 1791-92, the reach and range of ethical interpretation of rights was being powerfully expanded by Thomas Paine's Rights of Man in 1791 and in Mary Wollstonecraft's A Vindication of the Rights of Women with Strictures of Political and Moral Subjects in 1792, and also in her earlier books on the rights of men. Neither aroused Bentham's curiosity. Bentham's dismissal is easy to challenge, since ethical rights may have nothing other than a motivational connection with legislation and legal rights. Herbert Hart's view that people speak of their moral rights mainly when advocating their incorporation in a legal system indicate that while a legal right may well be seen, as Bentham argued, as a child of law, a claim to a moral right may well serve as a parent of law, motivating and inspiring specific legislations. When Christopher Pankhurst asserted in his speech in London in 1911, I quote, "We are here to claim our right as women, not only to be free, but to fight for freedom," adding that this is, I quote again, "our right as well as our duty, unquote. When she did say this, she communicated a strong normative claim that was not yet legislated into British law, and yet it communicated plenty to those who were speaking, indeed those who were reading her writings or speeches. Women did not have the right to vote in Britain in 1911, nor would that right be achieved until 1928, 17 years after Pankhurst's speech. Women would start voting the following year in 1929. The suffragist agitation, of which Christabel Pankhurst was a major leader, and the public discussion that went with it on women's right to vote would materially help in the process that led to the actual legislation to give women the same voting rights as men in Britain already had. There can in fact be little doubt that the idea of moral rights can serve, and has often served in practice, as the basis of new legislation. However, legislation need not be the only way of giving expression to ethical rights. To acknowledge that a strong connection exists between the ethics of human rights and legislative motivation is not the same thing, as I think Herbert Hart rather hinted he might take that view, as taking the relevance of human rights to lie exclusively, or at least mainly, in their playing an inspirational or justificatory role for actual legislation. It is important to see that the idea of human rights can be, and is actually used in many other ways as well. It's easy to appreciate that if human rights are seen as moral claims, indeed as moral rights, then surely we have reason for some catholicity in considering different avenues for promoting these claims. The ways and means of advancing the ethics of human rights need not thus be confined only to making new laws. Those who are skeptical of the idea of human rights would no doubt like to ask what could be the way of testing whether something should be seen as a human right or more generally as a moral right. Where is the normative basis of human rights? How should we judge whether and why to take them seriously? In the theory cited earlier of seeing objectivity in terms of survivability in public reasoning, the plausibility of ethical claims or their denials must depend on how they can be expected to fare when they encounter unobstructed debate and scrutiny along with adequately wide informational availability. The connection between public reasoning and the formulation and use of human rights is extremely important to understand. The soundness of the normativity of a claim for a human right would be seriously undermined if it were possible to show that they are unlikely to survive open and informed public scrutiny. Normativity and social and political decisions is closely related to their robustness in public reasoning. Now, there is a meta-ethical question into which I do not intend to, do not want to enter, but I want to air what it is. I'm not entering. So I'll not enter here, despite the temptation I have to admit, into the meta-ethical question, which has been much discussed recently by Derek Parfit, Tim Scanlon, and many others. Whether the test of public reasoning has only evidential value, it tells us how strong the arguments in their favor are, or has constitutive role, survival in public debate, makes them valuable. My own inclination is towards the former interpretation, seeing public reasoning as ways and means of recognizing the cognitive standing of rights. But in terms of practical use, the two perspectives do not substantially differ, and in this conference I'm not going to dwell on that distinction. The discipline of practical use requires to make, however, some circumstantial distinction, and that is important. In particular, and that applies to both interpretations on the meta-ethical side. In particular, the importance of human rights cannot be discarded simply by pointing to the fact that in politically and socially repressive regimes which do not allow open public discussion, many of these rights are not taken seriously at all. Open critical scrutiny is as essential for dismissing a normative claim as it is for defending that claim. A pronouncement of human rights is an assertion of the importance of the corresponding freedom, the freedom that are identified and privileged in the formulation of the rights in question. For example, the human right of not being tortured springs from the importance of freedom from torture for all. This goes with the affirmation of the need for others to consider what they can reasonably do to secure the freedom from torture for all. For a would-be torturer, the demand is obviously quite straightforward, to wit, to refrain and desist. The demand takes the clear form of what Immanuel Kant, in the Critique of Practical Reason, called, I quote, a perfect obligation. However, for others too, that is those other than the would-be torturers, their responsibilities, even though they are less specific and come in the general form of what Kant called imperfect obligations. Imperfect obligations are general duties of anyone in a position to help to consider what he or she can reasonably do in a matter involved. The perfectly specified demand not to torture anyone is supplemented by the more general and less exactly specified requirement of imperfect obligation to consider the ways and means through which torture can be prevented, and then to decide what, if anything, one should reasonably do in the particular case in question. I should clarify a distinction that I have discussed in my book, In the Idea of Justice. It's important to emphasize that the recognition of human rights is not an insistence that everyone everywhere rises to help prevent every violation of every human right, no matter where it occurs. It is rather an acknowledgement that if one is in a plausible position to do something effective in preventing the violation of such a right, then one does have an obligation to consider doing just that. It's still possible that other obligation and non-obligational concerns may overwhelm the reason for the particular preventive action in question. But that reason cannot simply be brushed away by arguing that it is, quote unquote, none of my business. That's where the distinction is. Imperfect obligation must not be confused with no obligation at all. A theory of human rights can leave room for further discussions, disputations, and arguments. The approach of open public reasoning, which is central to the understanding of human rights, as characterized here, can definitely settle some disputes about coverage and content, but may have to leave other possibilities unsettled, at least tentatively. The admissibility of a domain of continued dispute, and this, in my judgment, is a very important issue, is no embarrassment at all to a theory of human rights. For that is the nature of the subject matter we are dealing with. As Aristotle argued in the Nicomachean Ethics, we have, I quote, look for precision in each class of things, just as far as the nature of the subject admits, unquote. The likelihood of distinct perspective raises an important issue of what may be demanded of reasoned resolution. Is a dispute over a pair of alternatives, X and Y, resolved only when there is an exact agreement on the ranking of X and Y? If there is an agreement that if there are other issues such as ranking of A, B, C, D, and others, on which there is already an agreement, the pursuit of the implications of that agreement need not be held up by trying to resolve their impasse over ranking of X and Y. If we agree on not ranking X and Y in either way, formally leaving that part of the partial ordering incomplete, how would decisional reasoning proceed? And how would a reasoned resolution be put into action? This is a question that seems to me to demand a lot more attention than it has tended to get, both in terms of analytical and mathematical reasoning, and in terms of their normative and ethical implications. I shall come back to this question before I finish this talk, but there are other issues on which I would like to make a few remarks first. As we mentioned earlier, At least in his later writings on justice, John Rawls has tended to confine the condition of survivability in unobstructed debate within the national boundaries of a sovereign state, following a tradition established by Thomas Hobbes. In contrast, Adam Smith had argued in the Theory of Moral Sentiments, and also in the posthumously published The Lectures in Jurisprudence, that the normative viability of a claim must also be examined from, I quote, a certain distance. Adam Smith's approach has considerable bearing on seeing the viability of the normativity of human rights in terms of vindication in open public discussion with adequate information in real or imagined global encounters. There is a similarity here also with Hugo Grotius's invoking of the role of international law, even when no formal legal agreement has been instituted. Beginning with the Free Sea, published in 1609, Grotius looked for reasoning that could, at least in its basic appeal, transcend the local boundaries of the state. I tried to discuss that issue in my Grotius lecture, Global Status of Human Rights, which came out in the American University International Law Review in 2012. Smith was very concerned about avoiding the biases of ethical myopia within a nation and beyond its borders. Rather than trying to cater only to the dominant views of ruling groups in any country, Smith saw the need to bring into perspectives for other groups and other classes whose views were often ignored in national decision-making. This was for him a principal way of transcending, among other barriers, the limitations of class-based thinking, a subject on which Smith, contrary to what is often recognized, was at least as firm as Karl Marx would later be. Smith also used the need for broader evaluation to assert the necessity of seeking global argumentative encounters, actual or visual or virtual, in checking the plausibility of normative claims. Global examination of each other's position, Smith argued, is both feasible and important if people go into it with genuine curiosity rather than a sense of racial or ethnic or national superiority. The problem of communication may come often from the arrogance of the more powerful than from the intellectual or educational limitations of the downtrodden. When Adam Smith burst into something of a rage, and it was a real rage if you read the passage, on the pretensions of the slave owners in the 18th century world about their superiority over other human beings who were being enslaved, the indignant Smith remarked in the Theory of Moral Sentiment, I quote from the Moral Sentiment, "There is not a Negro from the coast of Africa who does not in this respect possess a degree of magnanimity which the soul of his sordid master is too often scarce capable of conceiving," unquote. There may have been some exaggeration in that angry response, and yet the idea of racial, ethnic, or national superiority continues to have a debilitating effect, often implicit, even today, that demands critical assessment that goes beyond local endorsement. In his recent book, The Court and the World, Justice Stephen Breyer has argued for the need for the interpretation and enforcement of American law to take note of new global realities. He has pointed out that the U.S. Supreme Court has to deal increasingly with foreign activities, and there are new challenges arising from an increasingly interdependent world. He argues for taking note of many voices, including quote-unquote representatives of foreign governments who can explain relevant policies, foreign lawyers who can describe relevant foreign laws and practices, and ordinary citizens whom our decisions may well affect, though they live and work abroad, unquote. The force of this conclusion can be, I believe, strongly supplemented by invoking Adam Smith's advocacy of bringing in perspectives from a certain distance. And it's a different argument from Breyer's. One of Smith's illustrations of parochial values that needed confrontation with views from elsewhere refers to the tendency of all political commentators in ancient Greeks, including sophisticated Athenians, no less, to regard infanticide as perfectly acceptable social behavior. I think I should mention here, as someone who is rather involved in with Smith, and that it's one of the peculiar things that whenever he discusses evil practices that need intervention, these are attributed to or observed in what are regarded as being finest societies to the audience he's addressing. It is never a thing of what happens to other countries far away from the Western world. It's always, that's his argumentative strategy, which I think is quite powerful. By the way, I comment on it. I did the Penguin anniversary edition on the 250th anniversary of moral sentiment, theory of moral sentiment, which had to be published in 2009 since it was written in 1759, and we succeeded in making it on the 29th of December of 2009. I have a long introduction where I discuss both the substantive moral positions of Smith, it's not a book on economics, and as well as his nature of argumentation. Smith pointed out that even Plato and Aristotle did not depart from expressing approval of this extraordinary practice of infanticide, which I quote from Smith, uninterrupted custom had by this time thoroughly authorized in the local culture, unquote. Smith's invoking of the idea of an impartial spectator, a collectivity of imagined observers who provide reasons that locally confined debates may overlook, serve many purposes, including to prevent the mesmerizing effects of what Smith called self-love. But among other uses, it could serve, Smith argued, as a device to avoid being captured by the limitations of parochialism in locally confined reasoning. There's a kind of generic relevance of wanting to check whether some practice appears acceptable only in local and parochial assessment. This led to Smith's insistence that, I quote, the eyes of the rest of mankind must be invoked to understand whether punishment appears equitable, unquote. The necessity of this arises, Smith argued, for the avoidance of bias related to individual and sectional interests, but also to just the limitations of local parochialism. I quote Smith again, we can never survey our own sentiments and motives. We can never form any judgment concerning them unless we remove ourselves, as it were, from our own natural station and endeavor to view them at a certain distance from us. But we can do this in no other way than by endeavoring to view them with the eyes of other people, or other people are likely to view our practices, unquote. If this argument is correct, then the deliberations of the courts, including the US Supreme Court, have to take note of foreign arguments and foreign practices, not only because of the new reality of interdependence, on which Baer comments so powerfully, but also because of the old reality of possible parochialism of locally confined arguments. Even though the case for taking note of what happens abroad and what is argued abroad may be much stronger today, as Justice Baer has shown, there might never have been a time when the national shutters could be sensibly closed. I turn finally to the discipline of reasoning, as I promised. The demands of disciplined reasoning is often wrongly interpreted as the pursuit of optimality, thereby making it a more forbidding social task than it in fact is. In a widely used approach, reasoning is taken to be incomplete until a conclusion emerges that is at least as satisfactory as every other conclusion. Formally, this insistence on optimality involves the identification of an ideal or a best alternative. And this search for optimality has to be distinguished from maximality, seeking a conclusion that is no less satisfactory than any other conclusion, whether or not it's actually the best. The distinction between maximality and optimality is often overlooked in presentations on reasoned ethics. It's, however, a major contrast. An alternative is optimal only if it is at least as good as every other alternative. In contrast, an alternative is maximal if there is no better alternative. To illustrate the contrast, when there are two alternatives, x and y, neither of which is judged to be better than or even as good as the other, there's incompleteness there, then in that pair of alternatives, x, y, both are maximal, but neither is optimal. While optimality entails maximality, the converse does not hold, and the two demands need not coincide even for well-behaved transitive rankings. As was mentioned earlier, this crucial distinction was well identified, I think I didn't read that bit, was well identified by Bourbaki in their classic mathematical treatise, Elements of Mathematics, published in 1939, with the special assumption in particular. I mean, they began with what they call pre-ordering, which is an incomplete order, with special assumptions in particular that there are no unranked pairs in a transitive ranking. The maximum will also be optimal, and the difference will vanish. But there's no analytical reason nor any practical necessity why the ranking of alternative conclusion must take this highly restrictive form. Even though the contrast between the maximum and the optimal may seem like an esoteric mathematical issue, the distinction is in fact of enormous importance for practical reasoning as well as for moral and political philosophy in general. Indeed, this formal issue is absolutely central, I believe, to the nature of substantive ethical argument, including the assessment of respective claims of alternative theories of justice. To allow the inclusion of unranked pairs of alternative is an integral part of the mathematics of relations and sets. That, of course, is well known, and we could discuss how central it is. What I'm arguing for here is the need to recognize that the existence of unranked pairs is an actual and may even be a common outcome of reasoned analysis of ethical and political evaluation. If it were claimed that there would be something of a mistake in a configuration that includes both these statements, that x is not at least as good as y, and y is not at least good as x, if we thought that to be contradictory, this would not arise from any analytical necessity, nor from the nature of practical reasoning. To get there, we have to impose some further restriction to ensure that the correct-incorrect dichotomy must, for some reason yet to be specified, take this particularly limited form. Such a special demand may take the form of insisting if that x is no better than y absolutely must be at least as good as x. However, if that particular very strong restriction were to be proposed, we have every reason to ask why. In effect, this would be an attempt to establish that there simply could not be normative evaluation that yields an incompleteness of rankings, an unusually restrictive demand. Note that contrary to an often made presumption, typically implicit, this is not an analytical necessity at all, and if for some substantive reason such a demand would be sensible to make, if it would be, then we must be given a reason as to why that necessity arises. To say that this would be helpful for decision-making would, of course, be to beg the question, aside from reflecting a failure to recognize that maximality is adequate enough for reasoned choice. 2.5 centuries of work on social choice theory has provided many practical examples of what can be called equilibrated incompleteness. Even in terms of general principles, there is no particularly compelling reason for insisting on the completeness of all binary relations of normative assessment. There is no great analytical and practical difficulty in having systematic and reasoned choice with maximality rather than optimality. And as I've already discussed, an agreement to leave a pair unranked may also arise from an unresolved difference between different parties, which is dealt with through a mutual agreement to not insist on ranking them in either way. Reasoned agreement may emerge despite different orderings or partial orderings that the distinct parties have, but which they are ready to incorporate, for at least time being, as an incomplete order or a partial order to be socially accepted. And decision with a partial ordering is a central exercise in reasoned choice. Buridan's ass, who is famous in the history of philosophy, faced just such a problem. I don't know whether how many people are familiar with Buridan's ass. This was a famous ass. I don't know whether it ever existed. He faced two haystacks. He was very hungry, but the both seemed very luscious. It couldn't determine which one was the better. And nor could it be sure that one would be at least as good as the other. And he dithered and died of starvation. That's the sad story. Now, Buridan's ass faced just such a problem when the famous donkey could not figure out which of the two haystacks facing it was better one to go for. And as this tragic story runs, the ass died of starvation from dithering. There's an alternative version of the story saying that it was indifferent and therefore didn't know which to do. But that seems even more asinine than you would expect an ass to have. Namely, if it were really indifferent, then either of them would be perfectly fine. It had to have this incompleteness thrown in to make any sense of the reasoning. It is possible that one of the haystacks was indeed larger and more eatable than the other. But if the ass could not figure out which one that is, it would surely have been better for the ass to go for either of the stacks rather than die of starvation. The analogy of that in the human rights debates about the world is quite easy to seek. So even with unranked stacks of hay, no identified best alternative, there is a reasoned approach to choice for Buridan's ass, to wit, to go for either haystack rather than ending up starving to death. I believe Buridan's ass died in the cause of optimal choice. In pursuing the role of reasoning in dealing with human rights, we need not do anything like that. Human rights demand more sophisticated reasoning than what the Buridan's ass pursued. Thank you.